to actually have an impact. What is your interpretation of the Continental Congress and specifically the movement through We the People?
Well, I talked to Bob Schultz extensively about this on Christmas morning of last year. So I'm familiar with at least with what he was planning on doing. I think he's following out that plan. Now, he has two elements in this Continental Congress. One is to discuss the freedom of petition question, because, of course, he's been working on that for a long time and has been unsuccessful in having his petitions appropriately or sufficiently answered, let's put it that way. And then the other point that he wasn't going to bring up, or as a result of my discussions, I understand he was going to bring up, was the question of the constitutional militia. And he was actually posing it as a question: have we reached a point in time where it's necessary for citizens to begin working on the revitalization of the militia? And the short answer I have to that is, in a sense, we already know the answer to that question, because the Constitution tells us that a well-regulated militia is necessary to the security of a free state. Read the Second Amendment, there it is. I don't think we need a further organizational structure to tell us that. The question then becomes, well, how do we go about doing it? And to say, I have a book out, which I plugged a moment ago.
Well, plug it again, Doctor.
Right, but I'm not going to stand in Bob's way, verbally at least, Bob Schultz's way, because I think it is not invaluable, or put it the other way, it would be valuable to have some kind of organizational activity like that to bring to the fore the recognition that there really is a national consensus among a large group of people that this country has gone in fundamentally a wrong direction, and that the only way to correct it is to assert primary constitutional principles. And the two that he has selected, freedom of petition and state militias, certainly are right at the top of that priority list, if they are not the very top. I would simply say that they go hand in hand, because what I'm proposing ultimately is that this be done through state legislatures, the people essentially drafting the statutes and telling the state legislators, pass this, and then we the people will implement it. And of course that is an exercise of what? Freedom of petition. So the two things go hand in hand. They're not separate and independent. I would simply say that it's more important to ultimately to organize people in these constitutionally based structures, that is the militia, than to spend a great deal of time with sort of private organizational efforts. You put out a constitutional convention, that's fine, but if you keep following down that road, that organization has no real constitutional legal authority. It's just a private organization. It's elected the delegates, and they've met in some hotel somewhere, and they've come out with resolutions. Whereas the militia of the several states are constitutional entities. When they are reformulated, they will have real legal authority, and then we can begin doing something.
Okay, Dr. Vieira, thank you for that answer. Thank you, Terry, for calling in. All right, now let's go down here to Karen on line 4. Karen, what's your question for Dr. Vieira?
My question is, I've been reading, and mine kind of goes with Liz's. You know, I saw where they were supposedly pushing the bills into the House to extend the presidential term past two deals, and they were talking about the different laws that they had pushed one through where they could go in there and push laws through at night and pass them when a lot of the people weren't there, and just, you know, run them through. And I've been reading that they were doing that. Can they legally do that, and can they change our Constitution while we're asleep?
No, because they have to have either a state constitutional convention, and they have to come up with a proposed amendment, and then they have to submit it to the states, and it can be passed either through state constitutional conventions or through the state legislature. So there's a procedure with multiple steps involved. What they could push through would be the proposed amendment, perhaps, but even then they're going to need to have the requisite vote in Congress. So the difficulty looking at this from the point of view of a bill passes if they have a quorum. And it's easy enough to get that when there are only a few people on the floor and others are paired, and so, I mean, they have parliamentary tricks to pull that one off. But in terms of a constitutional convention, no, that Congress is not the sole determiner of what's going to be even proposed as an amendment. If they create a constitutional convention to discuss amendments, it wouldn't be limited to the amendments that Congress had asked it to discuss.
We got Ralph on line 2. Ralph, what's your question for Dr. Vieira?
Well, I have a ton of questions.
Well, you only get one tonight.
I know, I'm limited to one. So the question I'm going to ask is regarding these oaths of office. How enforceable are they, and what's the mechanism for their enforcement as pertains to the constitutional comment about it?
Well, I would say that the mechanism, the obvious mechanism, a man who takes a false oath has committed perjury or false swearing, or there's a peculiar statute called the false statement statute. So theoretically, at least, if a public official takes an oath and it can be proven factually that he's knowingly violated this oath, then he could be prosecuted by the appropriate public officials at the state or federal level, wherever that oath was taken. Our difficulty is that they're all in bed together, that you're not going to find a federal prosecutor violating a federal official or a judge or a legislator. You're not going to find, very, very infrequently, you're going to find a state prosecutor going after some high-level state official. And, of course, the people don't follow. See, the problem is self-government is not a spectator sport. If we want to be in control here, we have to be vigilant watching these public officials. When we see them stepping outside of line and engaged in clearly unconstitutional action, which violates their oath, our first recourse is obviously at the next election to remove them, but that may be a long way away, to go to those prosecutors and demand some kind of action. If it's a situation where we could have some bill passed in the legislature to deal with it, lobby for that kind of legislation. But ultimately, this comes down to the question of whether we're willing to organize ourselves and take the time and the effort to enforce the Constitution when those public officials decide to act in what I call a rogue manner, when they're acting on essentially their own initiatives for their own purposes and just don't give a you-know-what.
I hear you, Doctor.
American.
Okay, thank you for that call, Ralph. Let's go down here to Kristen, I believe it is. What's your question for Dr. Vieira?
Well, I'd like to know what Mr. Obama would have learned at Harvard that made him think that he was a natural-born citizen, and as an extension of that question, how would he argue that the 14th Amendment defines it in such a way that he could be president?
Well, I have no idea what Mr. Obama learned at Harvard, because as I understand it, he's keeping all of his college records secret. Pretty difficult. That wasn't a subject that was covered when I studied constitutional law. At least it wasn't part of the curriculum in that particular course. So I don't know. But it seems to me he has a problem, otherwise he'd be releasing these documents for public scrutiny. The 14th Amendment, this is where it becomes interesting. The 14th Amendment, Section 1 says, person born within the United States and subject to the jurisdiction thereof is a citizen of the United States and of the state in which he resides. It doesn't say he is a natural-born citizen. And actually, there's an interpretation of the natural-born citizen clause and the 14th Amendment, which is perfectly consistent, which says essentially, yes, you can be born in the United States, but you have to be born of a father who is himself a citizen, because otherwise you would not be subject to the jurisdiction of the United States, because your father could simply take you off, and under the law of his country, as the law of Britain is and was, you would be a citizen of Britain pursuant to your father's citizenship. This question obviously is one that's going to have to come through the court system to have at least an initial determination. They could get it wrong, but at least initially to determine it, or else we're just going to be hanging here in limbo forever.
All right, thank you for the call, our gal. All right, let's move on to Roy on line 4. Roy, what's your question for Dr. Vieira?
Yes, my question is if we follow Dr. Vieira's strategy after the 20th and we challenge any law that he signs that he's not eligible to sign it, he's not eligible for office, and we get a superior district court to grant us discovery to look at the birth certificate, etc., can the Supreme Court pick that case out of any superior court or district court and bring it right up and bypass that proposition?
Yes, the answer is yes. They have certainly if it's in the federal courts, it's pretty easy to do because you can file a petition for certiorari, and actually you could file one, I suppose, if it came out of a state court. And theoretically, the Supreme Court could simply say, yes, we want to take this. What they would do, however, is they would allow the lower court to develop the complete factual record, number one, because that's necessary to be able to make a sound constitutional determination. We have to know the facts entirely. Secondly, I would imagine that they would let that case go up to at least one appeals court. So they would have the advantage of seeing a decision of an appeals court that would be based on more legal reasoning, more briefs filed, more research done, essentially to help them out and flesh out that case as much as possible. Thirdly, they might very well wait until there were 2 or 3 of those cases. They often do that. They often wait until there's a decision in a multiple number, certainly at the federal level, a multiple number of circuit courts, until they finally decide that the issue has been sufficiently discussed and illuminated, if you will, and then they'll take one or more of those cases up and make the determination. I would think, though, that the sooner they take it, the better, because the longer they let it go, more critical the situation becomes if it is determined that he was not ineligible from the beginning.
All right, Stephen, let's go to you on line 2. Are you there?
Yes, I am.
All right, what's your question for Dr. Vieira?
Yeah, my question is, since the Nuremberg trial has established that no government or its leaders can violate another's individual rights and sovereignty, that by putting a false president in, the whole government from top down will become illegitimate. So what is stopping us, we the people, from creating a tribunal and bringing them all to justice?
Well, I don't believe the government becomes null and void, illegitimate.